Welcome to Wills and Living Trust. How to avoid the three biggest mistakes that people make. My name is Hope Demps from Demps Law. During this webinar, I'm going to teach you how to avoid bad situations that occur in estate planning that I unfortunately encounter far too often. Did you know that according to the AARP, the average estate loses 5 to 7% of its value going through probate? Not to mention potentially years of struggle and fighting with your family. I'm hosting this webinar to show you how you can avoid all that. Okay, with that in mind, let me switch over to my slides and we can get started. During this webinar, we promise to teach you how to make sure 100% of your assets go to the people you love, how to avoid probate court, the differences between a will and living trust, why putting assets in your children's names may be a mistake, how to safeguard an inheritance from divorce, lawsuits, creditors, irresponsible spending, and more, how to provide for a beneficiary who receives government benefits. Plus, if you stay until the end, we have a giveaway. Stay tuned. Also, you'll be seeing a box below this video that says Q&A. If you want to type anything in that box, it will come to me, and I will get to as many of these as possible at the end of the presentation. If I don't get to yours specifically, I'll do my best to answer you directly over email as soon as I can. Part 1, what happens without a will? This is the biggest mistake, number 1, not having any sort of documentation, will, or trust for after your passing. This means regardless of what you want, other people are going to decide what happens to your money and property. It may be a judge, your spouse, a court-appointed administrator, your children, stepchildren, or siblings. This means your family is likely going to probate court and will have to deal with the fighting, time, and money I've alluded to, and we'll discuss in more detail. With that in mind, I'm going to start off with a story, Prince's story. So I want to start off with a story about someone you probably know, Prince Robert Nelson, or the artist formerly known as Prince. Prince ended up dying in 2016 at the age of 57 and left behind an estate in the hundreds of millions of dollars. And that's where the straightforward part ends. Prince definitely seemed to have some good legal instincts when he changed his name to a symbol to avoid royalty issues with Warner Brothers back in the early 90s. But he made a big mistake in not getting a will in place at any point in his career. Prince didn't have any children, and after he died, dozens of potential heirs started coming out of the woodwork. Over the last few years, most of these have been thrown out, leaving his sister and 5 half-siblings as the beneficiaries. But unfortunately, that hasn't stopped the conflict. The state of Minnesota had to appoint an administrator to take care of the estate, which is standard process, and the heirs weren't involved because the estate was complicated, hard to track down, and had to take care of some financial loose ends like back taxes. The administrator was initially Otto Bremer Trust, but is now being handled by Comerica Bank and Trust. Each of these have employed teams of lawyers and accountants, and 4 years in it has cost the estate $45 million, including $10 million in legal fees. The heirs are still on the sidelines watching this play out, fighting among each other, and there's no end in sight. You don't have to be a world-famous artist to have this kind of outcome, though. These things play out all the time when someone passes away without a will, when you don't want to be in my office. So, like many attorneys who focus on estate planning, there are 2 ways that I can help people. One is in the capacity as a litigator, fighting against another attorney to prove whether you or someone else has rights to something that your parents owned. The other way I can help people is by helping them plan ahead. When someone plans ahead, there are much easier options to go through, which I'll get to later in this presentation. But first, let's start with the situation we're trying to avoid. Probate. The process of dividing someone's assets after they pass away is known as probate. In most states, you can draft a will or a trust that allows you to instruct your heirs how to divide your assets. Or if there's no will or a trust, the law clearly explains how your assets will be divided, regardless of your intentions. The laws in place are meant to be fair. As you can imagine, there is sometimes a lot at stake financially, and people will sometimes try to do sneaky things to get more than their fair share of a person's estate. We're talking about made up documents, forcing people to sign things under threat, and all kinds of stuff you'd never dream of. In order to avoid that, you either need to provide very specific instructions regarding how you want your stuff to be handled, or it will go through a process to handle it for you. The state has a plan for you. Regardless of your wishes, if you don't have a plan or have a plan that doesn't hold up in court, you're going to go into the default situation, which is probate. That means your bank accounts, your home, your cars, and anything else you have. The estate is going to be handled by a person called a personal representative who will be chosen by the court if it isn't specified in a will. And that person will be responsible for selling any assets that will be divided, the cost of probate. So time is a big cost, but don't forget about the real tangible costs. That means attorney fees, paying an accountant, an appraiser, and potentially other professionals such as real estate agents or brokers. The value of any asset is determined at fair market value, so there are no ways to fudge these numbers. Around here, that basically means anyone who owns land or houses, anyone who has been putting money into their retirement account, has a life insurance policy, or even a few nice cars, will need a team of professionals to handle probating assets. An uncontested probate can easily eat up 3% of an estate's value, while contested probates get much more expensive with the additional attorney fees. In fact, reasonable fees are considered $3,000 plus 3% of the estate if there are no disputes involved. This means simple probate cases cost $4,000, and more complex cases can easily cost $15,000 or more. I've heard of contested cases where the personal representative and her attorney charged over $50,000. That's all money that isn't going to your family. Timelines. The overall process of probate takes months. We have to secure court dates for hearings, appoint a personal representative for the will, wait for creditors to make claims for debts against the estate, and anything that ends up being disputed. It sounds easy, right? Well, it can be when we have a simple situation, but those are very rare. When someone ends up passing away without a will or any record of their assets, the only person who has the full picture is not there to guide the process. New assets can come into the picture. Situations with deeds and bank accounts you might have never known about will surface, and any one of these can change what the interested beneficiaries want or don't want. Typically, this will end up taking 6 months for a simple probate where everyone agrees, while the average probate case takes 12 months or more. That can be 12 months or more of fighting and potentially not having access to the assets of the person who passed away. And there are situations like Prince's estate that take years or even decades to settle. Privacy and creditors. And beyond those fees, one of the nasty things about probate is that the law requires it to be put on the public record. This means all of the assets will be listed and filed with the court, along with documents that show who is to receive the assets. Everything filed with the court is available for anyone to see and make copies. Thus, probate court allows the public to know your business. If you have a mortgage, you'd better believe the bank is going to want to have a chat with your family about who is going to keep paying it. Or if you've taken out loans for anything else, it will be the same story. How well do you really know your family? The last and most important drawback to going through probate is the toll it takes on your family. Have you ever heard a joke about families that don't speak to each other for weeks after a heated game of Monopoly? Well, dial that up to 11 because a probate court case is doing that with real money and actual houses. All of the events that I've mentioned in this section are stressful in and of themselves, not to mention the fact that people have to grieve for the loss of a loved one. It is an absolute powder keg of emotions that really brings out the worst in some people. You may think you know your family, but I can tell you with certainty there is no way to predict how they will act when there is money on the table. Probate proceedings can change lives, and it's rarely for the better. When you don't have a plan for how you want your wishes to carry out, your family will be in a contest of wills, and sometimes in a contest of attorneys, like I've seen in many cases over the years. Families that battle it out in court are most likely not to spend Thanksgiving together anymore, and that's not something I want to see happen, especially when it's preventable. Part 2, the biggest mistakes. Sounds like probate isn't the way to go, right? I agree. But unfortunately, getting a plan in place isn't as easy as signing a piece of paper. This is actually the biggest mistake number two. Thinking you are set, ready to go with peace of mind, while in reality, you have an invalid will or unfunded trust and sending your loved ones to litigation anyway. Unfortunately, this is a mistake that attorneys themselves can cause who dabble in probate between criminal cases and divorces, not to mention all those legal document providers out there that advertise the do it yourself method. This is the real reason I founded our firm to help clients avoid spending money on estate planning, only to end up with a similar outcome as mistake number one, ending up in litigation and wading through the arduous court process to get things done. Even if you don't choose to continue working with me, I urge you to use an attorney and to ask that attorney how your planning works. If there is anything you need to do after you sign the documents to make sure your family is protected. I have another story regarding this. Another musician you may know and love, Aretha Franklin. Aretha had a huge impact on music, and her estate was valued at $80 million at the time of her passing. Now, the thing is, she did have a will, but the problem was she decided to do it on her own. You know, in the movies, when someone decides to handwrite a will to cut someone out or add someone in? Well, Aretha ended up taking this to heart and constructed several handwritten wills. Now, the challenge with that is we don't know which one she really meant. And now her four sons, who would have evenly divided her estate to a healthy $20 million each, are now spending hundreds of thousands of dollars trying to prove to the court that conflicting versions of her will that leave each brother most of the estate are the true version of the will that Aretha intended. This battle has been going on since 2018, and with the money at stake, you had better believe they are paying the best lawyers available to win, which could end up costing millions by the end of this, whenever that is, which could be a long time. And this is an example of how having the wrong plan can be even worse than not having any plan at all. DIY solutions. You might be familiar with one of the many online services that allow you to get legal documents generated automatically for a small fee. These companies are relatively new, but the concept has been around for decades. Before LegalZoom, you were actually able to get a blank physical will at Staples, and some states even provide these as a public service. Sounds like a great plan, right? I'll actually admit that it is. If you happen to have an incredibly simple situation, if you have very little assets and are in agreement with the state's plan about dividing them equally, these can work out. But the minute that situation changes, you have children or stepchildren, you get a house, you're going to be in a situation where a document may not protect you. By definition, these have to be one size fits all. Otherwise, how could they make these documents fit millions of people? Not to mention the laws are different in all 50 states, but these documents are often meant to fit everyone. Some of these documents are close to working, but close won't cut it here. Small issues that you may think of as irrelevant can cause huge issues. For example, one thing you must pay attention to is the name on the last page, but people often forget to put that in. You will see these documents getting invalidated all the time in court proceedings because they weren't updated or procedure wasn't followed to make them legitimate, such as two witnesses. The worst aspect of this, in my opinion, is that it gives a false sense of security. You think you're fine, but when the day finally comes, you've doomed your family to probate court. Concerns over witnesses. Remember when we mentioned that the law was in place to protect people from bad actors? One of the ways it does that is by having measures in place to prove that a document is legitimate. Otherwise, maybe a bad apple heir could come out of the blue with a document saying that the person who passed away left all of the assets to them, and there would be no way to contest it. Any will has to be proven in order to be legitimate with the signatures of witnesses. Some wills are even notarized. An issue that pops up frequently and one that often happens with DIY or inexperienced lawyer situations is not selecting proper witnesses. If you don't go through this process correctly and it can't be proven that the witnesses were present for the document, it may get thrown out the same way the document for the bad apple heir who wanted everything would get thrown out. And guess where that leads you? Back to probate court and the state's plan for your assets instead of yours. not funding the trust. We're going to get to what a trust is in a bit, but in short, if you put your assets into a trust, you can avoid probate by giving those assets to your family through the trust. The problem is sometimes people get the trust document, but they don't actually put their assets into the trust. This process is referred to as funding the trust. Any asset must be named and placed into the trust to be passed on and avoid probate. It's estimated that as many as 50% of current trusts out there are never funded, which is a shocking statistic. If this part isn't done, all your beneficiaries end up getting is a piece of paper. That is obviously not the outcome people who planned with a trust intended when they spent their time and money creating a plan for their loved ones. Which brings me to my next point. Not keeping the plan current. Life comes at you fast and situations change for both you and the law. Estate law is constantly evolving, and part of my job as an attorney is to keep up on it. Rules that were in place when a will was drafted may not hold up when a law changes, and on average, the law changes every 3 to 5 years. And your personal situation will also change. A new house, a new child, divorce, etc. These are things your plan needs to stay on top of. If a plan isn't updated, you might end up having someone who isn't the best option anymore end up in control of your entire estate. A really common thing you'll see with younger single people is naming their mom as a beneficiary for a will. Well, what happens when 50 years have passed and mom is receiving government benefits or has passed away? This is the kind of thing a focused estate law practice will be able to help out with, that someone who dabbles in the occasional will or trust usually won't have the time to do correctly. Failing to plan for incapacity. No one wants to think about bad things happening in the future, but it's always better to be prepared. This includes the possibility of becoming mentally or physically incapacitated. While older people are often more at risk of becoming incapacitated, anyone can be at risk of suffering an illness or injury that could cause incapacity. Unfortunately, this is something we see all too often, but those who fail to plan ahead can be subject to the many common horrors of the conservatorship and guardianship process. First, it will become public record if you become incapacitated, and anyone can seek to become a conservator or guardian, and generally the court will approve unless someone objects. Once a guardianship or conservatorship starts, it's like having probate every year, as yearly accounting filing must be presented to the court. This means the incapacitated person would need to attend a public hearing where the judge will assess their capacity, which of course can be quite humiliating. This process also creates so much additional work for the people you love. It's best to be avoided and can be with the right plan. Part 3, how to plan for success. Let's change gears and show you how you can do this right. The anti-story. I know we've covered a couple of unfortunate stories so far, but luckily they aren't all that dramatic. I have hundreds of positive stories I could tell you, but they just aren't very exciting. And that's what we aim for. This story is about my client Mary, who came in to see me after her husband Dylan had passed away from a long battle with cancer. Unfortunately, she had come to see me to help her with the probate process she was about to go through. Dylan had purchased a cheap will online, and the court had decided that the family still needed to go through probate. After the probate case was over, Mary wanted to make sure that her kids didn't have to go through the same thing with her, so she had us set up a will and trust for her. About 2 years later, she called me. She knew her time was coming to an end as her health was failing and wanted to thank me for helping set up her estate planning. Not 1 month later, she had passed away. Instead of worrying about how her kids were going to pay for the funeral, they were able to draw from the estate, and everything was easily handled for them. They were able to honor their mother with a beautiful service, and within 2 weeks after the funeral, all of Mary's assets were dispersed where she wanted them to go. There were no claims against the estate, no headaches, and no drama in the family. I know this because Mary's son then called me to let me know, and also thanked me because he knew how difficult his father's probate case was for the family. But the plan I prepared avoided all of the hassle, time, and money. Not a very exciting story, is it? That's what we want. I've seen families fall apart due to an unexpected death, and it's not pretty. We want your legacy to live on and for your friends and family to be taken care of without the added stress of probate. My philosophy: peace of mind for our clients. everyone has different needs. My philosophy on estate planning is that I want everyone who walks into my office to leave with peace of mind. We've gone over a lot of ways this kind of thing can go wrong, but with the right plan and documents in place, you'll be able to go through your life knowing that your wishes will be carried out no matter what happens. Another thing I firmly believe in is that peace of mind comes from the right plan for you. There is no perfect one-size-fits-all estate plan. It's about what's right for you and about creating a plan that works with your family's values. Everyone needs to have legal documents in place, but depending on the amount of assets you have, you might need to consider tax implications for your heirs, and you might even have the option to do more with your money than you thought possible. What is a will? The first important document you need is a will. When done properly with the appropriate witnesses and all of the stuff we've gone over, a will is instructions to the court on how to divide your assets. Even the most advanced estate plans will include a will. One of the things to keep in mind, though, is that a will still requires your heirs to go through probate, with all of the costs, delays, and exposure associated with that. The big hassle you are able to avoid with a will is how your assets will be divided. Your will also dictates who will be in charge of managing, selling, and transferring the assets to the right people. So assuming everything is done properly and is up to date, you can save your family the conflict of deciding who gets what, the longer timelines associated with hearings, and in most cases, avoiding litigation between family members down the line. What is a trust? A trust is a much more sophisticated document that gives you the flexibility to divide your estate without going through probate. You can put your house, bank accounts, and anything else into a trust. When you put the things you own into the trust itself, you're able to avoid probate entirely. Trusts also allow you to choose how and when people receive their assets, which can be a very important thing in some situations, such as if you have young children or heirs who might need more financial guidance. Going beyond legal documents, you absolutely have to get your legal documents in place. But when we're after peace of mind, there are other things to take into consideration for most people. We like to think of documents as one leg of the stool. Whether you're leaving behind money, a house, or something else, Uncle Sam is going to want a piece. The way you set up your documents can have huge implications on how much of your money goes to your heirs instead of to the tax man. So tax planning is a second leg of that stool. We also have some taxes that are harder to see. Unless you've been managing to avoid all forms of news for the past year or so, you're aware that we have inflation going on right now. Not having money that's growing faster than inflation means you're paying an invisible tax. So our third leg of the stool is financial management. The inheritance no one wants, tax burden. Let's talk about taxes for a bit. When most attorneys talk about estate taxes, they talk about the inheritance tax. The federal limit is just north of $12 million these days, which most American families don't have to worry about. But that threshold is dropping by about half in 2026 if Congress does nothing, and could drop even lower if they do decide to act. So for anyone near the threshold of $6 million or even less, depending on how much of a risk you want to take with the actions of Congress at stake, should be thinking about federal estate taxes. It also doesn't mean you don't have to worry about your heirs paying other taxes if you don't have to worry about estate taxes per se. Let me use the example of the IRA beneficiary trust that we set up for clients that have an IRA. As you may know, you pay taxes on the front for an IRA, so you don't have to pay them out on the back end as long as you're older than 60. The key word in that scheme is you. There are rules where your spouse can inherit it with the same rules, but once you get a child or anyone else into the mix, it becomes a taxable event. That person has 10 years to withdraw the entire amount of the IRA, which is taxable at their current tax bracket, which could be as high as 37% of the total value. Very few attorneys, let alone everyday people signing up for an IRA, are aware of this kind of thing. This is one of the strategies we use to make sure your heirs get as much as they can. I've also seen clients try to give assets to their kids before they pass or name their kids on the account, which can also have tax consequences. Creating generational income streams for normal folks. There's a huge gap in the country today when it comes to financial management. On the one end, you have people who are 100% DIY. If you're saving money, you have your 401k or your IRA and maybe invested in an index fund or do some stock picking. On the other end, you have the stuff you see in the movies and hear about on the news, hedge funds, wealth management funds, and that sort of thing. Without exception, every family with a high enough net worth has professionals taking care of their money. When you have the right team in place, your money works for you. It grows when you're living, and it can continue to grow when you're gone. Instead of leaving heirs with a lump sum, there are ways to leave cash flows that continue to pay long after you're gone if you have the right team in place. But what about the rest of us? But for everyday people, it's tough to get access to the best professionals. If you wanted to become a private client at JP Morgan Chase today, you wouldn't get past the secretary on the ground floor at that office if you didn't have 10 million in net worth. For most of the people that are under that limit, you're limited to retail financial advisors. Now, don't get me wrong, we work with financial advisors all the time, and there are some great ones out there. But there's also a dark side of the industry that takes advantage of hardworking people who trust financial advisors with their life savings. Many financial advisors are paid on commissions. Sometimes they're getting commissions on the best product for the client. Sometimes they're recommending the product that pays out the highest. Interests aren't always aligned, except for one case. What is a fiduciary? If you haven't heard of this, some financial advisors are what's called a fiduciary. Fiduciaries are legally and ethically bound to place their beneficiaries' interests above their own. If they break the rules on this, there are very harsh penalties. This is the highest standard for financial management and the hardest one to uphold. So if there's any doubt on the quality of financial services, this is what I always recommend for our clients. Do I need a will or a trust? So back to the legal part. Do you need a will or a trust? Everyone needs a will. Some people need a trust. I'll give you a classic lawyer answer and say, it depends. Here are the major reasons I would recommend a trust. Assets over $100,000. If it doesn't seem clear by now, I'm not a fan of the probate process and what it does to families. There are absolutely situations where it would cost more to get a trust than one would stand to lose through court proceedings and legal fees. Based on the numbers from the AARP we went over at the start and others, this number is a lot lower than most people think. It's not just the Rockefellers of the world that need a trust. If you have assets worth over $100,000 on average, it will be much less expensive to have a trust. Now, keep in mind, this isn't the amount of money you have in your checking account today. This includes your home equity, your financial accounts, your 401k, and IRA if you have one. And one a lot of people tend to forget, your life insurance policy if you have one. Having any of these individually can put you over the $100,000 net worth mark, and if that's the case, I generally recommend a trust. Owning a home or real estate. If you own your home, I always recommend a trust because a home is a big asset and oftentimes tied to a lot of memories. It's one of the things you'll see fought over the most in court. As we've gone over before, you may think you know your family, but it's very easy to get heated and fight over a home in court, which means more money spent in the course of a probate. Even if your heirs get along perfectly, you now have a situation where they are joint landlords. With the equal split that is the default in state law, everyone will have a portion of the home. If they decide to sell it, it's almost inevitable that there will be conflict. One person will end up doing most of the work, one of the siblings will want to hold out for a better offer, and somebody will refuse to sell at all. By using a trust, you can set out specific rules for how you want your home to be handled, who to have it go to, how you want it sold, and who the proceeds would go to, and the list goes on. It's a much more flexible way to set up rules on your terms. People with minor children. One group of people I always recommend getting a trust is people with minor children. There are a lot of reasons surrounding guardianship, which could be the subject of its own webinar, but something that always raises eyebrows when I bring it up is, without a trust, your kids will be getting everything the day they turn 18. Now, I don't want to make any assumptions about you or your life, but I can say from a personal perspective, I was not at the peak of my fiscal responsibility the same year I graduated high school. If I had received any significant money at 18, I would have partied like a rock star and been broke by 19. Eventually, I did grow up and become much more responsible. The likelihood of an inheritance making life easier for your children goes dramatically down if they get it at that age, and the chance of it actually hurting them through poor spending or dangerous habits goes up quite a bit. I haven't seen an official study on this, but a comparable situation I like to point people to is lottery winners. Over 70% of them end up going broke within a few years, and over one-third go bankrupt after getting used to spending the money. All of this can be avoided by setting rules for distribution in your trust. Don't let this happen to your kids. Special needs dependents. Special needs dependents can be in trouble if they end up receiving assets in a lump sum. There are big costs associated with caring for people with special needs that will often last their entire lives. In addition, we have state and federal programs to help pay for these. When someone with special needs gets a big distribution in their bank account, it can kick them off their benefits. They'll end up footing the bill for their own care until the money goes out, and then they'll be back to square one with applying for benefits. A much better situation is to get this into a special needs trust that can be structured to make sure they have money for care and other things in their life for as long as possible. Problem children/challenge dependents. Now, this is one that isn't super fun to talk about, but a big reason to have a trust. This represents a bucket of people who would be in a bad spot if they ended up getting a lot of money. If you have a child or dependent that has a serious issue or maybe has had one in the past, money can be very dangerous. We're talking about stuff like drinking problems, drug problems, gambling, bad business decisions, and that sort of thing. In some of these scenarios, the best outcome is the inheritance gets wiped out in short order. The worst case scenario can be life-threatening. When a probate or will is settled, the money will be given in a lump sum. But with a trust, you can set up rules as to when and how money is given out. A simple way to address this is by splitting the inheritance into annual or monthly payments, but you can get as complex as requiring stuff like drug tests, full-time jobs, or education in order to receive installments. This can turn a nightmare situation into a way to get people to do better for themselves, which is what this is all about. Appointing a trustee other than an heir. While we're on the subject of problem children, let's talk about another option you might have, which is appointing a trustee. When your estate plan includes a trust, you need what's called a trustee to oversee where the trust ends up going. In a lot of families, this will go to a close friend or the most responsible child, but I'm sure you can think of some families where a responsible child isn't available. Here's another thing we see all the time as attorneys in this situation. You have the responsible one set up as the trustee, and on paper, they have all of the power to distribute the trust. Unfortunately, that person is also human. So when other heirs think they aren't getting a fair shake, they will sometimes try to pressure the trustee who might be their sibling in other ways. If the trust is written properly, it will be very hard to change your wishes, but it's a very uncomfortable situation for the trustee. So a great way to avoid this is to hire someone other than a personal acquaintance to be a trustee. There are fees associated with it, but for a lot of people, this is a great option. Next section, second marriage and blended families. So we've gone over how the default rules of probate have their limitations for a nuclear family. Well, those limitations become even harder to deal with when you consider the blended family, as we learned during our first story. The truth is, a lot of these rules were written when people didn't live to the age we do today. Divorce was rare and remarrying even more rare. So if you have a blended family or children from a previous marriage, things can get very complicated very quickly. When we're talking about second marriages with children involved, almost no two situations are alike. And the default situation with probate almost never reflects the complex real life relationships. So if you have a second marriage or blended family, I would highly recommend looking into a trust. A well-crafted trust will allow your second or third spouse to be given what is needed, but leave something for the kids from your prior relationships and marriages. Self-employed or business owners. People who own a business or are self-employed have different circumstances than people who work regular jobs. In a word, it comes down to risk. If you take someone like a doctor who owns a small clinic, for example, you have exposure to lawsuits for malpractice, which inevitably come up over time. Even attorneys like me are exposed to this sort of thing. Believe it or not, there are a number of business specific structures that can help out with that. But having a trust in place can stop people from going after assets you want to pass on to your family in the event of something bad happening. In addition to this, the default rules of probate court can make your kids equal owners in your business or any stake in a business you have. Most people I know have definite preferences in terms of who they would want to have that, to say the least. So I would definitely recommend a trust and specific planning for that. What's your story going to be? Which is a great segue into what I want to leave you with. We've talked about legal documents through this presentation, and I've also told you some stories. So I want you to think about what your story is going to be. What you set up with your plan or lack of a plan is the epilogue of the story of your life. We've gone over stories that end with families being torn apart. And if I can help one person on this presentation stop that from being their legacy, I can consider all of this having been worth it. So what's your story going to be? Now, let me answer some of the Q&A questions that have been coming in. I have a will from 11 years ago. Will you take a look? We'd be happy to take a look at your will. I can tell you right now that if it's from 11 years ago, there have probably been some changes to your life circumstances since then. So go ahead and book a call with us to check it out. We can let you know if it needs to be adjusted or what good next steps will be for you. If we plan on having more children, should we wait? Definitely not. The important thing is to get your estate plan set up as soon as possible. You'll always be able to amend it later when life events like having more children happen. One of my parents went into a nursing home. Is it too late to protect those assets? This is a great question. Just because someone is in a nursing home does not mean they can't do estate planning. The main question we have to ask is if they have capacity. You do have to have a certain level of mental capacity to execute these documents. So the answer to this one is it depends. If this is something you're worried about, please go ahead and give us a call and we can look into this for you and get you an answer. I don't really have that large of an estate. Do I really need a trust? This is another one we get pretty often. Modern estate planning theory is that probate avoidance is the name of the game. In most cases, if you own a home, you can still benefit from having a trust, even if you don't have that large of an estate. If you have any questions about if a trust is right for you, feel free to reach out and we'll help you decide. So if you've made it this far, something is resonating with you and we are here to help. As I promised, I have a special offer for you. If you received all you need from this webinar, you are free to go. But for those who are interested, let me tell you what I have for you. I want to offer a 60-minute session with me or someone on my team to help you out with getting your assets protected. The truth is, everyone has a unique situation with their assets, family, and needs, and it takes expert help to make sure you have the right legal plan in place. There's no substitute for sitting down with a professional to get this set up, but the plus side is once you get it set up, you can have peace of mind knowing you and your family will be taken care of in almost any situation. If you walked in the door of our office right now, we would need to charge you $300 to sit down with me and my team and get your situation assessed. We typically charge upwards of $750 an hour, so we can't offer this to everyone. But since you've taken the time to listen to this webinar and understand what's going on, we're willing to make a special offer for people who are on right now. Now remember, getting the documents in place will end up costing money. Compared to what will be at stake in probate proceedings as we've gone over in this session, it will be much less. But more importantly, you can't put a price on peace of mind. So click that link to set this up while we still have spots available. And that's pretty much it. I sincerely appreciate you investing your time and energy into this webinar. It shows how committed you are to making sure your family and the people you care about are taken care of. It's really a special thing in this day and age, and there are very few people willing to do what it takes. And obviously, you are one of those. Thanks so much for attending. I look forward to seeing you again soon.